Ladies and gentlemen, and welcome to this edition of FOL Justice Forum on Focus on Liberia. My name is Dennis Jai, and we are broadcasting from Atlanta, Georgia. Of late, there have been some legal issues in Liberia. It started with the case involving the former Chief Justice Gloria Mususcat and her family members, where they were charged with murder. We will be looking at the crime, murder and capital crimes. We want to be discussing that because in the light of that case, there were a lot of things that we heard. People with charged with murder can be bailed out or they cannot be bailed out, or and all these different things. So we have assembled the best team when it comes to legal on internet television, so we can talk about that legal murder and capital crimes. Also, there was a time that the LRA, I think they closed down most ability radio station, all that. So we want, and also they have sometimes the LRA say you owe taxes. So we want to look at the authority of the Liberia Revenue Agency, LRA. We want to look at that. Quite recently, Spoon TV and FM, the Spoon Network was closed down, and they had something called action of damages by attachment. What does that mean? So we're going to look at all this. We also see areas where some people are practicing law that are not lawyers. Is that what it should be? Is that how it looks? And what really does practicing law mean? Like the way I'm here now, I have these two gentlemen. I'm not practicing. We were going to look all into that. With me, we have our legal analyst here, FOL, Councillor Frederick A.B. Jayweh. Councillor Jayweh, welcome to FOL Justice Forum.
Thank you, Dennis. I'm always happy to be back and to discuss the issue.
Thank you. Let me also welcome the CEO and host of 2A Radio and TV, Attorney James N. Jensen. He's always here when we call upon him to assist in understanding and these matters. Attorney Jensen, welcome to the show.
Well, Mr. Todd, thank you so much for the invitation. And I want to say to my learned colleague, Councillor Jayweh, it's a pleasure to share the platform with you. And to our listeners, it's a pleasure to have you listening to us. We are not here as superhuman beings. We hope you will ask all the necessary questions, and we hope that we be prepared to discuss the topic as selected. So I'm pleased to be here.
We want to welcome all our viewers from across the globe. Wherever you are joining us from, this is Focus on Liberia. This is the platform where we educate, we elevate, and promote all things Liberia. It is very easy to discuss legal issues in our mouth without even being lawyers. But sometimes these legal issues, sometimes these issues get so convoluted, and political people discuss them as if they have, legal understanding. Sometimes they are right, sometimes they are wrong. That's why we call the lawyers here to help us understand. So here are the things we want to talk about. And as I told you earlier, we want to talk about murder and capital crimes. We want to also talk about what is action of damages by attachment and the authority of the LRA. Here are the questions. What is murder and how does this crime impact an accused? What is meant by action of damages by attachment? And C, can the LRA shut down a business operating in Liberia in the absence of judicial proceeding or the due process of law? Let me start by getting your welcome, your opening statement on why it is important to discuss this, and you can give us some background. Let me start with Attorney Jensen. Why is it important really sometimes to come here and, I don't want to say teach, but discuss these kind of legal issues?
Well, thank you again for the invitation. It's a pleasure to have Councillor Jayweh with me discussing the topic. Well, murder is a very serious crime because from the days of old to this time, life is precious, and no one has the right to take a life of another person. And that's why it is a capital crime in Liberia. So in the case of Shala Musu, May also rest in peace. Right now we are talking, but she's gone. We will not see how the parent going to grieve the rest of their life. So we are glad that this matter has gone to court, but we are very concerned as to whether or not those persons charged are in fact the killers or the killer, or there is a killer among those three persons. So we are concerned. So we will discuss this on the periphery or on the surface because this matter is in court. And so my presence here is to look at what is murder, as you said. Murder is taking the life of somebody who should not die in fight. You have no reason to kill somebody because you are not the one that gave life. So yeah, we are here to look at the elements of murder and the culpability. I will not go in detail of that because we believe that, there's a case ongoing. So indeed, on the issue of the LRA, there are some things that are really happening in Liberia. And Liberia, if you look at what is happening, it's like becoming a failed state. Now, I'm carefully saying it's like becoming a failed state. Everybody can get up and do anything. Even issues that a minister or a director could be dismissed for, people don't take action because probably the leadership, if the leadership do not understand governance, do not know that Liberians, there are more capable Liberians who can perform the job, we keep people on the job who will even be doing wrong things and will not give opportunity so that you can have Liberia be made better. And with that kind of situation unfolding, everybody seems to know the law. Everybody seems to be the best government officials. Everybody seems to be everybody in Liberia nowadays. Everybody want to be loyal. And so they don't care. As a result, there is no example being set. Some of us who took our time to go to law school, we did not do it because we wanted to shortcut the system. When I was in high school, I had a very tough time. But trust me, I used to walk like when I was on Ashmont Street, walking from Ashmont Street, going to 12th Street. And I was taking tough courses, chemistry, physics, math. If you got home, no matter whether you have food to eat, you had to sit to study your lesson. And so we felt that society there was a standard set. So some of us took our time to go through all of those strenuous process because we felt the only way I can succeed is to fight to be at the top in the learning sphere. But today, the example that being set on the stage of governance is completely different. So people don't even regard education these days. Somebody will feel even getting on talk show and just talk trash is an important thing. They feel they're providing education. And that's why I encourage some of us to come on show like this. That's why when you send me invitation, it's not to come and show my face. I don't need that. I know what life actually means. I know the emptiness of my body when this breath leaves me. So I'm not coming to this show because I want somebody to see me. I'm coming because we do not want empty voices to be seen as the voices of truth. And so I'm glad to be here. Let me stop here and give and keep the ball rolling as we go further.
Thank you. Councillor Jayweh, give us some background here and why this is important.
As Attorney Jason started off, and as a question raised by your show has said, we are interested in discussing what is murder and what are the rights of those who may be charged with murder. Are they entitled to bond? And again, this
Are you freezing there?
I think there's something wrong with the system, huh?
even I'm freezing. Okay, we're back.
Okay.
What are the rights of people charged with the crime of murder? Murder is a capital offense. Murder, by definition, is the taking of another human being life without the appreciation of that life. But when the crime of murder is alleged, and in the case of Gloria Scott and her relatives, or anyone else has been arrested and charged with murder, we need to distinguish between a charge purported by a magistrate or justice of the peace and a formal indictment. What are the issues? What are the steps that are surrounding that? And again, as Attorney Jason said, it baffles me that I find politicians and people with no idea, I'm saying no idea, of what the content and context of the law is, and decide to hold a show and say things that they got no business saying, or they have no understanding as to what they are saying. And it has become a commonplace that former government officials, have started to discuss legal issue as if they have the authority to discuss it, as if they understand what the issues are. And some of them have started to even mix up what is a civil matter as compared to what is a criminal matter. And it also have gone so far that I'm also taking aback that, and I met her here, she's still here, I think, Her Honor Francis Johnson Morris, raised the issue of students being given grace at the law school, grades being changed for people to graduate, even though she, as the instructor of a course, have written the university and how those kind of issues being, how the bar sits there and does nothing about people who comes on with show and discuss, not inviting the lawyers, but discuss the show as if they themselves have some kind of background to be able to educate the public. We think we need to educate the public. That's the reason why I thought, and I'm sure Attorney Jason will say the same thing, that this show is very important, because it will clearly say, you're hearing it from people who have spent years going to law school and spent years practicing law. You're not hearing it from a former deputy minister. You're not hearing it from a senator. You're not hearing it from government officials who think that, they have some kind of association with somebody who was a lawyer or who is a lawyer. You're hearing it directly from those who have gone to law school. And I think this is the important thing about it. I think recently we all saw how the Spoon television station was closed down. And I saw the sheriff, I think there were 3 or 4 of them, where there will be locks in the hand and locking the doors, including the gate. Again, what is an attachment? Can a lawsuit, can an action of damages for libel or slander be instituted by attachment? If so, what are the authority of the court and court officers? Those things we need to discuss them, because they are meaningful to the discourse. The other thing I wish to discuss, which we didn't mention, is that how are indictments formed in Liberia?
Yeah, that's a good one. I will include that. So let's start with murder and capital crime. So, Anthony Jensen, you can start with that. Why, Councillor Jayweh, your connection? I don't know. You on a computer or phone?
No, on a computer.
Oh, okay.
It keep going. I think all keep going off. I don't know why.
Right. So we'll start with murder and capital crimes, and the main question we want to discuss here: what is murder? How does this crime impact an accused? And say murder is a capital crime. So I ask, what is capital crime?
Okay, the first thing is let's go to the Liberian Constitution. What does it say as to capital offenses? All right, there are grades of criminal offenses, and capital offense is one of those high crime for which one can be sentenced for life, or under the Criminal Procedure Law Title 2, you can even be put to death. So that shows how serious capital offense is. So under Under Article 21 of the Liberian Constitution, DR says when someone's life is taken away, that's murder. All right, that's a crime. If John killed Peter, John is alleged to be the killer of Peter. So that's what we call murder in the simplest sense of saying, which everybody will know. Oh, John Brown was killed. John Brown was killed. So it means if Peter killed John Brown is killed. But then it comes to the point where the court get involved only when certain actions are taken. In the case about the late Cllr Mosu was killed, thus the act of murder coming into the fold. So the question now was that who killed Cllr Mosu? That's the answer that the court will have to address. But until then, there were other things that needed to take place. In my view, there was a need to have coroner there to do all the fact findings and collect all the whatever that needed to be done, police investigations, and I'm sure police may have done their best. Let me not say because we didn't know what they have, but they may have gone there to do all of the scientific things they needed to do so that they could find the killer. Now, the police has come out to charge 3 persons as being responsible. Those 3 persons, and in as much as we may not agree with some of the procedural steps, but that is fine, to send people to jail, to arrest them so that they can have their day in court. That's a fine step from the beginning to this point. We not care whether these people were the actual doers or not, but what we cared about is that the procedural step from that point to this point, I think they are on course. That people were charged, people were accused, they've been charged and sent to court. Now, the issue of whether these people are entitled to bail, we take cue from what the Constitution says. And I will take it to Article 21 DR, where it says all accused persons are entitled to bail, with the exception of capital offenses. Even with that, it says as the law will provide. So in the mind of the framers of the statute, the Criminal Procedure Law of Liberia, Title 2, they went, and because of the ambiguity that exists within Chapter 21 DI, they decided to expand the provision, thus creating the statute explaining how capital offenses can be bailed. So in my understanding of the law, both the Constitution Chapter 21 DI and the Criminal Procedural Law Chapter 31, 31 point, am I right? Let me
31.1.
31.1, right?
13.1.
Okay, I mean, 13.1, right? Very good, thank you. 13.1 and 13.2, you will get the clarity that even capital offenses and all offenses, because they take you from the constitutional right of everyone in Liberia. Your liberty cannot be seized without being tried, without due process. So yes, even capital offenses, they are entitled to bail as per these 2 laws that we quoted here. So how do that interplay? That is beyond my jurisdiction. We do not know how to quote the methodology or the roadmap of those lawyers, both defense counsel and prosecuting lawyers. We just say this is about the law. It's not the case. It's about what the law we have before us is saying, right? If you ask me, if someone committing murder, is that person, not even this case, is that person, going to court, can that person be bailed? I would answer in the affirmative. And that would mean the reliance is these pieces of law. All right? So that's what I would say as per what is murder. Like the killing of this guy is a clear example that murder has taken place, life was taken away. And what is happening now is everyone trying to know who killed this innocent girl for no reason. And that's why we are here. We can't hear you.
So in that case, should we say alleged murder until it is proven, or that can be murder before? Okay, the indictment can be murder, right?
No, murder has taken place. We don't have to say it's alleged, right? All we can say is that because it's physical, right?
But what if the
Shallow,
person died by themselves? So how do we know
no,
that murder has taken
someone has died. No, no, murder has taken place. Someone has died, right? A crime has been committed. What is important is that you cannot say, John Brown, you killed this guy. Even the government saying Grover Scout and the two other persons charging them, these people are innocent of the crime of murder. But murder has taken place. Someone has been killed. Murder is taking life. So you took Shala Musu's life, you are committed murder. What we do not know is who killed this guy.
All right.
So even those persons charged, you cannot say they are the killers until the government, the prosecuting team, can go to court and maybe we'll discuss some of those things, some of the basic elements of what constitutes murder, right? The mens rea, that physical act. And now this is where when you sit outside, if we must go in deep to discuss some of these things, what is physical to determine that consider Jayweh was the one who killed? What needs to be done? That showing is what the court will be after to show. Was it that those three persons took knife at the same time and stabbed the girl to death? Was it that somebody killed this girl and the other persons are accomplices? Now I say I don't want to go too deep into this because that would be like, opening eyes for what is already before the court. But I mean, someone has died. That's the important thing. Murder has taken place. What is important? Individuals have been charged of committing a crime. Those individuals will remain to be innocent. No one should say Grover has killed this guy. No one should say the two persons have killed this guy until the court, the prosecuting team can prove this case in the court of law, the best evidence presented, and then we're going to say, oh, the guy died on so time. And now the court has confirmed or has proven that these persons have killed this person. Or the court will come and say, well, the government has not proved a case. So they will say, why? The killer of Shala Musu is unknown, because if these people are declared innocent, meaning the person who actually killed this guy is yet alive.
Thank you. Councillor Jayweh.
Yeah, Daniel, let me just clarify your, give an answer and clarification to your question. In Liberia, every crime that is alleged to be committed are defined under Liberia Penal Code. So murder is not an alleged. Murder is a definition. It is a crime defined by the Liberia Penal Code. Those who are charged are considered as the accused.
Right.
They are considered that way because until the state can establish that they committed, or they go being specific, they honor Guerrero Musu's card, two family members were the one who killed Shala Musu, then you can call them a killer, or you can call them the killers. But until the case is established, which we will not go into because before the court, we just basically want to say that the crime murder is defined by the penal code. It's not an alleged. It's a distinct definition. And what is murder? The taking of the life of another human being without the appreciation. Now, I want to go to what my concern is, not just the Mususcat case. I'm concerned with the general notion in Liberia that when a Liberian or when anyone is charged with a capital offense, the murder, someone like treason, someone like sedition, that person or persons are not permitted to be bailed out because they have committed a capital offense and it's the highest crime of the land. Is it the highest crime of the land? Yes.
Yes.
It says true that they are not those, the accused are not entitled to bail? No. Following the citation that Attorney Jason from the Constitution, and I'll go a little bit into the explanation under Section 13.5 of the Bureau of Criminal Procedure Law. How is this? First, let me read 13.5. It's 13.1, sorry, 13.1, capital offenses. It said, a person in custody for the commission of a capital offense shall, before conviction, be entitled as a right to be admitted to bail unless proof is evident or the presumption great that he is guilty of the offense. Now, let me unpack this one. This is when a writ of arrest, when the government of Liberia goes to court, meet with a magistrate or associate magistrate and explain that the government is there because it needs a writ of arrest as the plaintiff in a murder or criminal case. The government is there, needs a writ of arrest to be issued by the magistrate because it is alleged that a murder has been committed. That certain group of people have allegedly committed murder. In this case, it would be the Mususka, it would be her two relatives and so forth, but it could be anybody else. So the government will just follow that procedure. When the magistrate listens to the government lawyer, Minister of Justice, Deputy Minister of Justice, any of the prosecuting attorney and the Minister of Justice, the magistrate will determine whether there is a probability of cause. Is there any real true or something sounding like true in this whole matter? If the magistrate thinks that, contemplates that, there is a probability that a crime or the crime of murder has been committed, the magistrate will order his clerk to issue a writ of arrest. It can be Gloria Mususka, Councilor Gloria Mususka. It can be any of our three relatives, or it can be anybody other than them. Let's put that out of the picture and say murder is committed, is alleged, is said to be committed in West Point. And John Jackson, along with his wife and two children, are alleged to be the one that committed the murder. The Minister of Justice will go to court and ask the magistrate to issue a writ of arrest. When a writ of arrest is issued and the defendants are brought to court, what are the steps or the procedure in there to say whether they should be granted bail or they should not be granted bail? First, the law, as read by Attorney Jason and explained clearly in the criminal procedure law, is that when the defendants are brought to court, the magistrate under Chapter 12 of the criminal procedure law, 12.1 up to 12.1 A, B, C, D, has a responsibility. Because the crime of murder is a capital offense, the magistrate or justice of the peace has no trial jurisdiction, cannot try the case. Therefore, what is before the magistrate, what the magistrate or justice of the peace must do is, one, the justice of the peace must educate, must inform the defendant that a crime, a charge of murder has been brought against them. That's the first one. Second, the magistrate must inform the defendant or defendants that they are entitled to representation of their choice. Thirdly, the magistrate of justice of the peace must inform the defendants or defendant that they have a right to preliminary hearing. Now, if they...
And where is that preliminary hearing should take place?
At the magistrate court. At the magistrate court. Now, many lawyers in Liberia don't take keen note of what I'm saying. They seem to follow the saying that, oh, the crime of murder has been charged. My client will be in jail until the case is tried. And when we win, the government cannot prove the case, our client will go free. That is creating hardship for your client. So what do? You got to be not just lawyers going to court. You got to be someone who is a criminal lawyer who knows the criminal law very well. Because what I'm saying is that for preliminary part of the rights of the defendant charged in the capital offense is preliminary examination. So if the magistrate did not, when the defendant appeared before the magistrate for the first time, the magistrate must go through the list I just made. If the magistrate, what happened in Liberia is that most of the lawyers will say that the magistrate will say, you are charged with murder. You have the right to a lawyer. You have the right to keep quiet and say nothing say nothing anymore. He does not mention that you have a right to preliminary examination. And the lawyers defending those defendants have not read the statute, they went to court, so they do not demand preliminary hearing. Preliminary hearing must happen when a writ of arrest has been issued and defendant or defendants have been brought to court. If the magistrate did not say that, then the counsel for the defendant must stand on his feet and say, at this stage, counsel for defendant move the court for preliminary hearing because the magistrate left it out. And when that motion is made, and it is the right, it's not maybe, it is the right of the defendant or defendants to have preliminary, it's a demand they can make for preliminary hearing. Now, what is preliminary hearing? At the preliminary hearing level, what the defendants are asking for is to have the court compel the state, the Republic of Liberia, to prove that proof is evident that they committed the crime, that there are evidence that they committed the crime. The defendant will not produce witness. They will make their demand. The government must bring all of the instruments they have, must bring the witnesses they have, people who testify. It's like a trial proceeding, except that the defendant will not put witnesses on the stand. When the magistrate, and there will be cross-examination, the witnesses, the applicants brought to court, the defendant will be required, the defense counsel will have to examine all of them and say, okay. And if the state did not produce witnesses and the instrument that led to the alleged murder or the killing of the alleged killing of the defendant of the child, or maybe a man or a woman, then the magistrate may at that level the magistrate may decide that grant the preliminary hearing. The hearing is done. The magistrate may admit that right after the preliminary hearing, the lawyer will then file a motion for the defendant to be admitted to bail, which is born under Section 13.1. Now, in my case, what I have done is that I will also pray for I will move the court for preliminary hearing, and also incite in my application that should the preliminary hearing not produce the type of evidence that is needed to prove that defendants are guilty, Your Honor, admit my clients to bail under Section 13.1. So you will have that application already in. Now, the mistake is that the lawyers for a defendant or defendant charged with murder in the Gloria Muzuska case, you cannot ask for bail before the preliminary hearing. Because if you ask for bail and the magistrate is not experienced enough, he will deny the application, and then the matter will be forwarded to the circuit court. In this case, criminal code A. Or murder or capital offense will be forwarded to criminal code A. You have lost the opportunity for preliminary hearing because you did not demand as a right for your client. In the Gloria Muzuska case, that's why.
Councillor, can I come in a little bit? I think, honestly, I want to respectfully look at things differently. I believed, in fact, this provision of the Constitution, 12.2, preliminary examination given on request only, that this provision need to be amended, because what am I saying? That I wouldn't want to waste my time at the magisterial court, honestly. My approach would be not to waste my time at the level of the magisterial court to ask for preliminary hearing, because there is a pending indictment process. So all that is taking place with preliminary hearing, the grand jury, if the grand jury go in there, all the pieces of evidence that the prosecution says they have will be presented. Now, even if you went before the circuit court, criminal code A, all of these things you said will have to be there. There's nothing serious that a magistrate is going to do with this case even when there's a preliminary hearing over there. What is important for me, and I wouldn't want to agree that I'm not talking about this case, but for me, I would think seeking for a bill is a matter of right, is a matter of constitutional provisions and the statute. And I see no judge knowing this law, if I was able to quote these laws for the understanding of the judge, a magistrate, will deny my client a bill. If they did, then of course we go upstairs, right? But I think the application for a bill would have been, because I look at the intensity of anyone being charged with murder. Whoever that is accused, that person going behind bar for the very first night. If somebody is even medically ill, that person could either die or that person's sickness could be worsened. So as a lawyer in that time, I would want to apply for a bill in the case. Now, preliminary hearing, yes, I agree. But if you even read 12.2 at the last end, it says what? After complying with the provision of section 12.1 of the title, shall hold him to answer. Meaning that's giving a clue that even preliminary hearing is not cognoscible or before the magistrate. Because except what, and I don't care, whoever wrote the wordings of this constitution, this statute, we probably hold them responsible for that. Because you see, if you say you're going to hold him to answer, suggests to me that you'll be asking the defendant, did you commit, whether you must say yes or no, whether you committed a crime or not. All right. So honestly, there's nothing the magistrate is going to give me right for my client. Nothing will do sufficiently that will satisfy me or my client. I will want to go to the next stage further. I want to speed a trial. I wouldn't want to waste my time, especially so if I know clearly that my client is innocent. I wouldn't want to waste my time. The drama will be at the because everything you do, whatever, calling for evidence, examination of evidence, most of the things going to take place at the circuit court, at criminal court A. I'm also.
So in essence, you are saying you can ask for the bill without a preliminary hearing.
Yes.
All right.
And that would have been my own methodology. My roadmap would have been, let me secure my bond first for my client, and then proceed with the full trial.
Let me for admission to bill, there are two processes. One, the statute say before an indictment, the defendants accused of a capital offense, like in this case, murder, as a right, is entitled to bill. That is before an indictment. After indictment, the defendants are also entitled to bill, provided proof is not evident and presumption is not great, meaning that after the indictment, the defendant must now prove that they did not really commit a crime and they want bill to be obtained before the circuit court.
Right.
The mistakes lawyers make is that I representing you as a defendant, I'm on a legal responsibility to ensure that they're thinking that because the crime of murder is charged, the client belongs into jail until the case is done with. I'm outside that notion. I want to
Nati, I agree with you on that. I
want to ensure that my client is well equipped, is well protected, meaning if the preliminary hearing is conducted, that's the reason why before indictment, preliminary can be conducted before the magistrate. I would not call it a waste of time, because should the law be read to the magistrate and the argument be clearly made, succinctly made, and the magistrate is convinced that, because mind you, before an indictment, the requirement to prove that murder was committed is on the state.
Right. I agree with that.
So you were set back, the defendant will not produce any evidence. Now, after the indictment, the responsibility to prove that murder was not committed by my client will switch on, will become our responsibility.
Yeah, burden was shift onto the defense counsel.
But prior to, that's why it's important. Prior to why the writ is issued prior to an indictment, the burden is on the state. So you can find out whether you will be asking questions like, take the Musu Scott case, the Gloria Scott. Did any one of all the witnesses the government bring on the witness stand? Each one of them are asked, did you see Gloria Scott? Did you see Rebecca? Did you see what other woman need? Take the knife to stab the late Shalom Musu? Did you see Gloria Scott? When you answer no, you finish. Did you see Gloria Scott? You answer no. Did you see them jointly holding the knife to stab her? I will cross-examine all of them on that.
But you wouldn't be allowed to the extent where, because you see, it's not only about saying these things, right? You look at, for example, this case, a magistrate, maybe your own argument or your own roadmap would be to get the case dismissed at that level.
No.
Okay, so if you're not doing that, I don't know why. I don't know.
No. Let me come back. No. This is a capital offense.
Right.
The magistrate has no authority, trial jurisdiction. So I will never be filing any motion to dismiss the case. No, I will never try that because the magistrate doesn't have the right to do that. The other thing I wanted to address is that if the magistrate denied the preliminary, as you said, then he was saying that the law says you hold him to answer. What that really means is that the indictment or the writ of arrest is still against you, will file the matter to the circuit court. Because that's jurisdiction. That's what it means. It doesn't mean did you commit a crime or murder. No, that's not what it means. What it means is that the defendant, as alleged in the writ of arrest, will be treated as defendant on a crime of murder and will be forwarded to the court. The only time a defendant will be let go or to answer yes or no will be before the circuit court. The magistrate has no jurisdiction. So there's a difference between preliminary examination and trial. The magistrate cannot. No lawyer can file a motion there. But what I'm saying is that if you don't do that,
so Councillor, in the Mutu Scott case now, because I learned they give them the bill and then they arrested them. So explain what happened.
No, they didn't grant them bail. Her lawyer did. The lawyer said that Gloria Musu Scott and her two family members, her Honor Gloria Musu Scott and her two family members, had been constructively detained.
Three family members.
Yeah, three, right?
Yeah.
Okay, yeah, the three family members. Well, I think there were 4. One person died.
No, Gloria Scott and then 3 family members. Two older women and a younger woman.
Okay, so then they are what? They are 4 currently before the court.
4 total.
Okay, so what they did what the police did, invited them at the police headquarters, and again they see erroneous belief. The guy, I think Colonel Mulba, I think that's his name. Colonel Mulba had a press conference and said, "We are holding them because we have 72 hours to hold them." So at the end of the day, a habeas corpus proceeding was filed to demand that Gloria Scott, her Honor Gloria Musu Scott, and her 3 relatives be released and set free because there had been no charge. And indeed, it appeared that there was no charge. So the judge Blamo Dixon, his Honor Blamo Dixon, went ahead and granted the habeas corpus. That's how you saw Councilor Gloria Musu Scott and her relative going home from the police station going home. The following day, about around 4, I think 2 or 4, the raid was issued, I understand 2 o'clock, around 4 p.m., the sheriff and other people went to their home to arrest them on a writ of arrest from the Maneuver City Court. That's how they were taken back to court, but they were not released on bail.
Right. So at what point? So why the still didn't ask for the bill? You can't ask for that at the city court?
Well, what the lawyers did was they left the provision for preliminary hearing and filed a motion to admit her Honor Gloria Musu Scott and her relatives to bail. That was a mistaken procedural process that they applied because the magistrate does not have trial jurisdiction. The magistrate will be inclined to say, "Oh, I can't try this case, so why should I be issuing bond?" But the magistrate has preliminary examination jurisdiction. So that should have been the first application before the court. And as if I were representing Councilor Scott and her family member, I would have moved for preliminary hearing and also incite into my motion that they be admitted to bail. So the magistrate will conduct the preliminary hearing because it says before an indictment. But if the reason is not to keep them in jail, the reason is that if you win that process before the magistrate court, your clients will be admitted to bail, they will be out. If you don't do that when you get to the circuit court, the circuit court will also make a decision. The judge in this case also ruled that they were not entitled to bail because murder is a capital offense. In my view, the judge is wrong. And if our lawyer in that case, I would have gone upstairs on a writ of certiorari.
I also heard that if they are not at flight risk, you shouldn't put them in jail, especially when it got to do with someone like Councilor Scott, right? Because that's what I heard. So I want to find out. Because the example they gave, they say, look at President Trump. I mean, he didn't go through the normal thing that every other accused will go through. So Gloria Musu Scott, the Councilor Scott, shouldn't have gone through, what she went through. In fact, you don't have to put her in jail. You got to let her go home because she's not at flight risk. I don't know if any of you heard that too.
I heard that.
Yeah.
Let me be respectful to the late Charlotte Musu. It doesn't matter whether Gloria Scott was Chief Justice or not. It doesn't matter whether she was Minister of Justice or not. It doesn't matter whether she was Election Commissioner Chair or not. It doesn't matter whether she was Senator from Maryland County or not. An alleged crime of murder as a crime was allegedly committed. Today, we don't know who killed that girl. I think she was 30 years old. A 30-year-old girl woman who about to graduate from college. I think it's SAR University. And the argument that she is a part of, when you're asking for bail, Section 13.5 takes into consideration that you look at the totality of the person involved. In other words, they have been Minister of Justice. She has a home in Liberia. She does not have property in the United States. She is situated. All of those become an issue. But if you rely upon the fact that these people, Councilor Scott and her Councilor Scott in particular, have been Chief Justice of Liberia, have been Minister of Justice, have been a senator, then you are saying that the little man can go to jail. And I'm not saying that they were soldier poor in jail. That's what I'm not saying. I'm saying that there should be the law doesn't respect you because you are a former Chief Justice. The law does not respect you because you are a former Minister of Justice. What I'm saying is that the law must take its course, meaning that if Councilor Scott, as the law requires, if Councilor Scott was to be admitted to bail, the preliminary hearings are being conducted. So she's not a fly rate. She will not run away at all. The court should take into consideration. But you know what Judge Willie said, the circuit court judge? He said, it doesn't matter whether she's a former Chief Justice, and that's true. The law is that it doesn't matter who is charged. What matters is that...
Councilor, can I come in a little bit? I think it matters because if you read the letters of the Constitution, Article 21D, it says all accused persons shall be bailable upon their personal reconnaissance.
Yes,
their personal reconnaissance.
I agree with you.
Yeah, the personal reconnaissance of Councilor Grover Scow, her status in society. Let's get this right. The primary purpose of an accused being on bail is to give trust to the court, because everyone should be concerned about the trial so that there can be a speedy process. If there's any evidence, whether bail or not, even with the provision, if there's any proof that an accused person will run away from the jurisdiction, the court has all right, the Constitution and both the statute gave the court all right to ensure that that person is held in jail, whether you come out or you whatever. But under this provision, personal reconnaissance should be given to Councilor Grover Scow. In no way that proof whether status in society or not, but that is a law, and the law does not even say, her personal reconnaissance. The law first says everyone is entitled to bail. So what is important now when giving somebody bail is the surety, the amount, and that is something the court going to do their findings on, whatever property value, whatever the situation is. So Councilor Scott, as we see her, Can she run away from the court? Can she commit similar crime that is being alleged? Even, I don't think any of us will think that Councillor Scow will go and do those things or she will run away from the country. If there's any reason to think that way, of course the court will be right to deny her bail, despite even the wording of the Constitution and the statute.
So I agree with you. Everyone charged with capital offense is entitled to bail. My contention is the argument should not just be centered on that this person was former Minister of Justice.
So what is this personal?
You can list personal reconnaissance will include all of those, but it does not. You should not argue zeroing in on exclusively that these are the things. But the law requires that if you then in the argument you have to ask the question: is Gloria Musu-Scott someone who is capable of running away from this country?
Fine.
When you're arguing before the court, you must ask the kind of question.
Right.
Does Gloria Musu-Scott have property sufficient in this country for which she cannot flee the country?
Right.
The other question you ask in arguing would be: is Gloria Musu-Scott a threat to the society? If she's released on personal reconnaissance, looking at her status, looking at all of the things, but I'm saying you cannot make the argument to only stay around there. You got to go beyond there.
But I mean, this is a case that really embodied them now. So the fact the Constitution says all Liberians, and it's the backdrop of that is that everyone has a right under the law.
Now
it's thank you, guys.
Everyone charged, not just Liberia.
Okay, everyone charged, right? Everyone accused.
Yeah. I'm saying that we arguing, you have to basically let it be known that you are not just dwelling on
right.
The other thing, but I'm saying Bill Section 13.5 says that she's entitled to the bill just by looking at her and looking at her status.
Right.
That she done.
Right.
But
that's
you can't argue still like that. If you do like that, then you create a problem.
Okay.
And then what I thought would have happened is that the lawyer for Councillor Sky would have gone to the Supreme Court to be able to demand that the judge admit her to bail, and let the Supreme Court say no. The statute say that the capital offense is a major crime in Liberia. She cannot be admitted to bail. At that level, we got the interpretation of Section 13.5, 13.1 to 13.5. We also have the Constitution interpreted by the Supreme Court. That's what I would do.
Thank you, gentlemen. That takes us to our next point here: action of damages by attachment, and this is related to the Spoon Network case. And I don't know if I still have that, but let's examine it. On that morning, we saw the lights, we saw the sheriff, and I didn't even know what was going on. I was like, and most people, is it that the government again? They are trying to muzzle the press, and even Unity Party issue a statement, right? But then, as I talked to lawyers and readers, that's where the time I heard about this action of damages by attachment. What does this mean, and how does it relate to the Stanton Witherspoon and Spoon Network case?
You want me to start? I can start.
No, the Antonio would like to go first. He said,
yeah, I wouldn't have a problem, right? The first thing is let's understand the. Let me admit here, I don't understand the totality of the issue by, but let me say this: what I know about filing a lawsuit with an attachment. In the case of what we hear in the LRA, when I hear about LRA, it means then that either there was some default in maybe taxes or whatever obligation. But first and foremost, an aggrieved party should have filed an action before court. And based on that, you could have filed the action first and then filed an attachment, or you have filed the action with an attachment at the same time. And then the attachment would be to request the court to seize the property of the person who complaint is being filed against. Now, let's say, for example, if there was an action of death or whatever the facts of the circumstances is, Spoon is a media institution, and all we saw was sheriff lacking the premises of the media institution. So if there's an action for damage, the first thing that came to my mind was this, and I think I even posted on my page was that it says something that we really do not know, because before you can close a business center or even go into someone's house to evict them or to eject them from a piece of property, there might have been a series of actions. There might have been a case filed, and then the individual would have been called to court to appear in court and show why, they cannot be evicted or their property cannot be locked, or in the case of an attachment, why their property cannot be used as a collateral gain for a particular action. So I said to myself, I think there is something that the public is not aware. And I was even saying, look, the Spoon management needed to come forth and say what actually has happened. It said that they were cited by the court on numerous occasions and they failed to appear, and upon which the court took an action to close their station. If not, then no one, neither the government, should ever attempt to close down a business house or even someone's personal property without a due process, without going to court and seeking the necessary action for the court to take the action that they need to take. So I'm not still understanding this Spoon situation,
Right.
whether or not there was they were cited on numerous occasions and they failed to show up. If they failed to show up, then of course we will say the court would have been right to take action against them. But again, if the court herself did not, they gave these people the opportunity to be heard, and that arbitrarily took a decision to go and close down the port business, then of course the court or such would have known better. They don't just take instruction from LRA and move straight to a business center and decide to close it down. There are procedural steps, all the procedural steps are laid down in law. And I'm very sure the government has capable lawyers who can represent them and make sure that they don't breach these provisions of the law. It's not a benefit to anybody just get out and move to somebody's business center and close it down. But hey, the government says should also be able to explain to the public. Right. And their action would have been very clear. If they cited these people maybe 2 or 3 occasions and they failed to do so, then if the government acted, then of course we would think the government would act. But maybe Mr. Councillor Ray will know the detail of this case better than I do. All right?
So let me brief the case.
Okay.
As we would say at the law school.
Get the facts, yeah.
There are 2 distinct cases here. One, LRA is separate from the lawsuit before the civil law court. LRA is not a party. The case that grew, that from which the attachment proceeding grew, has nothing to do with LRA. LRA is not a party. There's a young man, or there's a man, or there's a former, deputy at the Legis. I understand his name is Wilmer Smith.
Okay.
Wilmer Smith was the deputy and at the Legis. He had filed a lawsuit against Spoon Network, and Mr. Stanton Witherspoon, claiming that the network, including its former CEO, malign, tarnish, defame, slander his name. Shorty said they call him a criminal. So he filed an action of damages with attachment to have the Spoon Network pay, I think, $1.5 million.
Yes.
In the case if judgment is entered in their favor. So LRA had little or nothing to do with this. It's not even part of it. It's not for. It's not
okay.
Court. Whether Mr. Witherspoon and the network authority, the Spoon Network Authority, ever went to court or refused to go to court when the writ was served, it appears to me that after the action was filed, and Mr. Witherspoon has not discussed it because he said the case before court. He's correct, he will not discuss it before court. But the question of whether or not the lawsuit was filed without the attachment. That's how it appears to me. It seemed like the lawsuit was filed without the actual damages for slander, or filed before the civil law court without the attachment proceeding. And it appears that when the sheriff of the civil law court went to serve the writ of summons along with the complaint for damages, Mr. Witherspoon does not live in Liberia. He could not be found. And I think other people, it appears that the people, and I'm saying appear because none of them have said what was the issue. And when I watched the video, it seems that there was a problem. It seems that there appears to have been a problem. That no one received the rate of summons. First, it was a rate of summons along with a complaint. That's why I assume. Everybody apparently at the Spoon Network decided not to receive the rate. And then the plaintiff, which is Mr. Smith, he and his lawyer may have applied for attachment because, according to them, if they get a judgment of $1.5 million, then there will be nobody available to certify the judgment. So then the attachment was to go out, the petition for a writ of attachment. There are two proceedings here. Petition for a writ of attachment is a proceeding where in the defendant properties are seized and brought under the jurisdiction of the court. If the defendant is available, the defendant could be arrested and brought to court. Even though it's a civil matter, the defendant could be arrested and brought to court. But it appears that the sheriff and I think there were about 4 of them, they went to the Spoon Network with big locks and entered, I think, almost all the offices and were locking up the offices. Attachment does not give the court that authority to lock down an office or a business place because there's a lawsuit before the civil law court or any other court wherein money judgment is involved. What the attachment does is that if you read the section 7.11 A to E, which is the civil procedure law section 7.11 A to E, it lays down what's supposed to be done. Properties are seized. The reason for why the properties are attached and seized is that after the judgment, after the case is heard, and if the defendant, say Spoon Network, Mr. Witherspoon and others were found liable as charged to pay $1.5 million, then the court will have in its possession property that belong to Spoon Network and Mr. Witherspoon to be sold, to be auctioned and sold. But it does not give the court the authority to go and start putting locks. The only time you lock up a place is when there is an actual ejectment and the defendant are supposed to be kicked out of the building, or there's a summary proceeding to recover possession of real property. And the defendant loses the case and he's supposed to evict them. So they will put them out and lock all of the door. But in an attachment, you don't lock the doors. You attach. Or I would have thought that they would have taken the microphone. They will attach the microphone. They will attach the transformer. Everything else that has to do with make it that you can sell and make money, they would have taken it under their custody and taken it to the court. But what they did, you can tell that this case, even though the government came in, which is interesting to me. Somebody said that, I'm laughing, I think it's Jeru Gibson, said that in Liberia there's a parable that when Madhu men come to your town, you will say, my man, in this town, you can't follow people with women. And then Madhu men will say, but I'm not following anybody woman. But they're not accusing you. Why is the government making press release to say, we're not in this case here, we're not in it. The case is between Wilmot Smith and Spoon Network and Witherspoon. Why is the government writing? Why is it necessary for the government to write a press release? The government is not a party.
Right.
The case in court is Wilmot Smith versus Spoon Network and Stanton Witherspoon. So why do you write press release? So in other words, what I'm saying is that an attachment does not give the court, does not give any court the right to shut down a business place.
Councillor Jayweh, you said they can attach the microphone, but they can't attach the building?
So unless a building is owned, most of the buildings like that in Liberia are rented. Right. At least. So if I have my law office on Broad Street, I'm leasing the place. It's not my building, so you cannot attach it. because you can only attach what belongs to me, because at the end of
Right,
the
the
day,
personal
the
property.
case is over. You will sell properties that belong to Councillor Jayweh. You can attach my car, you can attach my land, things that in my name that are owned, or things that in the name of the law office that the law office own. But you cannot attach the building because it doesn't belong to me. I'm a simple renter. And my ownership of that building is to just use the space. I can't sell it. I can't do anything else. It's just to use the space. So you could not have locked it. And in order to lock the place, it must be an ejectment proceeding. Not. Let me read for you what attachment is.
Yeah, let's get to that attachment. And why is it issue?
Let me. It's section 7.11, ground for attachment. It says an order of attachment may be granted in any action where the plaintiff has demanded and where there is reasonable ground for believing that he would be entitled in whole or in part, or in the alternative, to a money judgment against one or more defendants. So you got the Standard Witherspoon himself is a defendant. The Spoon Network also a defendant. The action is to recover 1.5 million. So the issue of money judgment is there. They said when a defendant is a foreign, this is when attachment must be issued. When a defendant is a foreign corporation or not a domiciliary of the Republic. The defendant is a domiciled in the Republic and cannot be personally served despite diligent effort to do so. The defendant is in the country. The business is there. Nobody want to receive the summons. Or they can't even be found, so they can be served. That's one of the grounds when attachment can be issued. See, the defendant with an intent to defraud his creditor or to avoid the service of summons has departed or is about to depart from the Republic, or keeps himself, let's ask the herself, concealed therein. D, the defendant with an intent to defraud the creditors has assigned or disposed of or secreted property or removed them from the Republic of Liberia. So A to E are ground. Is a Spoon Network about to hire itself, for which an attachment should be issued? Is Mr. Witherspoon, is the Spoon Network a foreign corporation? No. Did the court officer report that they could not serve the network and the official? Because the Spoon Network is a corporation.
Right.
The way they were sued is another issue that I have, but I will not say anything about it because it matters before court. And I think that represented by a lawyer. Because normally, a corporation and an individual cannot be sued together. A corporation is a person with the right to sue and be sued. But again, that's a lawyer. They can handle that. I will leave it with the lawyer there to handle it.
You said you were not going to say, but you still say.
Yeah, but
So, Councillor, there was this also that this is a civil matter. I heard that a lot.
Yeah. Let me.
You can do attachment because it's a civil matter. Is that?
No. Again, I mentioned that, and I think Macaulay also said that Liberia has become overflooded
With lawyers, then?
all themselves lawyers. I was listening to the Spoon Network on one of these days. I think it was Thursday or Friday, one of these. And one of the presenters, I wouldn't call her name because I want people to be able to listen to it and see that presenter. I think the presenter was making a big fool out of himself by saying attachment is a criminal case. Attachment, do you know, Mr. Witherspoon, you could have been arrested if you were in Liberia, because this is what the Liberia criminal law provides. So there's a difference between the substantive criminal law and there's a difference between Liberia criminal procedure law. Attachment is a civil proceeding, meaning actual damages by attachment is a civil proceeding. What it means is that I think Daniel Jah has done something to me, has defamed my name, slandered me, and I decide to sue. It's a case between private parties. That's what makes it civil. The case between the Republic of Liberia and Gloria Mususka and the rest of it is not a civil matter. It's a criminal matter because a crime is alleged to be committed. In a civil matter, unless it is an attachment where you may be arrested. No arrest occur in a civil matter. So it is very different. It's not a criminal matter. Even though it says that you may be arrested under the attachment proceeding, but it still grew the whole action grew out of a civil case. A plaintiff, a private parties, Mr. Smith suing Spoon Network and suing filing.
Is it freeze?
Yeah. Ladies and gentlemen, if you're just joining us, this is FOL Justice Forum. We are discussing three issues here. Number one, murder. What is it and how does it impact the defendant? Two, the action of damages by attachment that happened in the Spoon case. So, Counselor, if the building belonged to, let's say, owned by the Spoon Network, it can be attached.
Yes.
So the assumption is they are leasing it or they are renting it.
So I don't know whether they are renting or they're leasing. I got no information. But what I'm saying is that in order to attachment can only be served on properties that are owned by the defendant. And even
so, if they attach it, could they seal it up? Let's say if the building belonged to the Spoon Network, could they seal it up because it's attached?
Well, the law on attachment says that all of the properties owned by the defendant should be kept under the custody of the court until the case is determined. So yes, if the building belonged to Mr. Witherspoon bought by him, but that has to be established. Then it can be attached. And not to be established by Mr. Witherspoon and Spoon Network. It will be established by the plaintiff that filed the lawsuit. In other words, he or she will go to the Minister of Finance and find out whether the building in question, how many lot is on, who actually own it. Go to the what do you call it, the deed, the what do you call the deed, you can go to the probate court perhaps, but you go to the archive. They are forgetting. You go to the archive and try to establish all. You go do your research to find out whether Mr. Witherspoon owned it, right. And it can be attached. And so it could be locked because it's supposed to remain under the jurisdiction of the court. If the judgment is against Mr. Spoon Network and Mr. Witherspoon, the house, the building you see, if it's owned by him, can also be exposed to auction, sold, and to certify the debt. But if it's not, then you cannot lock it up.
So the condition under which, and I'll make the first assumption, let's say the building belongs to the Spoon Network. Second, if they have ignored the rate or refused to take it, right?
Mm-hmm.
When it was issued, then they can do the attachment. But because this was the first time, even though the case doesn't involve us, so we shouldn't know. But is it possible that the Spoon Network did not take the rate because Stanton is not in the country? So why couldn't they serve the CEO of Spoon, who is right there in Monrovia? Were they probably looking for Stanton instead?
Let me say what I saw on the video. When they went to serve the raid, and the court officer, the video they posted on YouTube, there were people in the network. I think there are about 3 radio stations or television stations in the same building. Well, I think one is upstairs, I think 2 downstairs. The people who were there were saying that the CEO, the current CEO, Titi Kane, I think her name is right, not available, so we now hold the rate. And I think the court officer, in fact, they were telling the court officers to wait until Titi Kane could be called for her to come. I think she was not at work on that particular day, or she was somewhere. She did come though, and sign for the rate. Now, we don't have the facts to know whether the action damages for slander were filed along with the attachment jointly at the same time. We don't have the information to that. And if it was not done together, you can do it at the same time, or you can do it if you think fear arises that the judgment may not be certified. You can then move to court when the action is pending. You file a petition for attachment. And if the court order the rate to be served, and it's not granted at that level, the rate will be served and the party will come to court. It will be represented by a lawyer, and the lawyer would, and both lawyers will argue, the plaintiff lawyer and the defendant lawyer will argue. And if the judge deem it necessary, the judge will grant the attachment. But and if the defendant did not file a bond to lift the attachment, meaning to remove the attachment for the case to be tried, because none of these things that you're talking about, spoon network is running away, Witherspoon is running away, everything else, or they are not properly to certify the judgment. So then, at the end of the day, the court could basically go ahead and hear the case. But what it is that what I know of recent, and maybe starting with what you call the Front Page Africa. There was a case against Front Page Africa where lawyers were representing Front Page Africa when it got, and Front Page Africa lost in the civil law court. Doctor, I forgot his name. Doctor, Ellen Johnson, Christo, filed a lawsuit for the same thing, slander, and Front Page went to court along with the lawyer for Christo. Front Page lost the case in the court below. When time came for them to file the bond, the lawyers who were representing Front Page, Mr. Sear said that he would not follow the process of filing the bond because he did not trust the process. And so that's how you see he was arrested and sent to jail. There were press people making noise and say, oh, a pressman has been sent to jail. But the pressman has said that he will not honor the documentation from the court or follow the steps for appeal. If I were representing him, I would have just waiting to him. And then also inform the court that I cannot continue representation, because you cannot say that you'll be served with a summons and you will not go to court. The other thing that I've been hearing in Liberia is that I'm representing a case now that will not call the person's name, is that the person, it is alleged that the person said that the person lawyer in Liberia, somebody that she designated as his or her lawyer, said that whenever they sue my client, let them bring the writ of summons and a complaint to me. That lawyer has a problem because no lawyer is served with a complaint unless that lawyer is a defendant. You do not represent the client until the client bring her file to you, say, right. I have been sued. So you cannot ask the court to come to your office to serve you. So that could be some issue, and there are some people who feel very too big, believe the system is corrupt, and so they will not accept writ of someone for any court in Liberia. And I don't know whether Spoon did that, but if that is the case, then you have a problem. You have created a problem for yourself. So the attachment, I assume, is proper, but I also got a problem to know why were they lacking the billing. Maybe the billing belonged to Mr. Spoon, but the plaintiff will have to establish that. For the document I've seen, I don't see anything establishing that. The other thing I saw, which I hope I don't wish to talk about, but I thought is interesting, is that the document that he sent to me, I read the power of attorney, and I asked the question, can an attorney, in fact, become a surety? The answer is no. You cannot become a surety. If I ask you, Mr. Dennis, you are in Atlanta, Georgia, I got 2 buildings there that I own, but because you are closer to the place and I'm in Colorado, you are my agent, work for me to put my building to rent, collect the rent and whatnot. I can't use a building to go to court and say these buildings I will serve as a surety. The buildings are not mine, are not yours, rather. You are my agent, but you don't own them. They are owned by Jayweh. Unless Councilor Jayweh gave you specific power, as in the power until that you have the right to sell my building as well as serve as surety, then before you can use that property. But again, Spoon Network is represented by lawyer. I assume that they will know all of that to be able to challenge this issue as it is. If not, that's Spoon Network. If Spoon Network is listening to one of its presenters that are calling attachment proceeding, criminal proceeding, then there's a problem right there. And then before we go from the criminal thing, there is a senator that feels that he knows enough of criminal law and had an exclusive show, Senator Dillon, and told himself that the proceeding before the court is not going well because the lawyer should have done this, the lawyer should have done that. If I'm a member of the executive on the executive committee of the Liberia National Bar with someone, the senator, with someone Dylan as a president, you come to us or will file a lawsuit against him.
Why?
Because what he's doing, it constitutes, he misleading the public. Secondly, it constitutes the practice of law. The thing that is a deputy minister on Spoon is doing and reading the law and say, this is a criminal law, making real big fool out of himself. When the attachment proceeding is a civil matter. It had nothing to do with criminal law. I thought he made mistake, no. But consistently over 5 different times, the presenter said, what you call it, attachment proceeding, it got to stop. We have to protect the profession. That quacks don't run around trying to advise people. People who had little or no interest, people who had little or no understanding on what is the content, what is this law? This law by attachment, action of damages by attachment, is it civil or is it criminal? You cannot talk about it when you have no background.
Thank you.
So don't tell the public.
Councillor, can you switch on your light there?
I think the sun is shining in. I think that's what the problem is. The sun is shining.
Yeah, that's Colorado, bro.
Yeah, the sun is shining through my office window. Let me address the
So Anthony Jensen, you have any final thing to say on this?
Yeah, my input in there is that when there is an action filed with an attachment, there are procedural that the parties will have to demonstrate. Like for example, if there's an attachment, it's not automatic. So that attachment, indeed, there's a trial ongoing, and then the parties who believe that assets of like in the case of Spoon, if they attach the property that Spoon is occupying to a libel suit, I don't know the facts actually in this case, then of course that attachment is not automatic. In the code of law, the code will have to establish, and even Spoon herself will have to be in court to say why the property should not be attached to the case about or whatever libel suit or whatever the case is. But what is more important in this case is that institutions, it should not be an arbitrary closure. Don't just move to a piece of property and decide to close it down. There must be right given to everyone. Right? Due process is a fundamental constitutional right that is accrued to everyone. So if you sue me for libel and you carry the case to court and you decided to attach my property to this trial, it is just fair enough that I be heard. And in that process, you can even establish the truthfulness of whether or not the property belongs to me and whether I am indebted or I have scandalized or I have written a piece of paper that in which damages the character of someone else. In the absence of that, I don't think it's a good practice. I don't think Liberia should encourage that. Like he cited the case of the front page. These are procedural steps that everyone go through. So I feel like, yes, even in this case, if there's an attachment, I believe in the code of law, there would be some procedural steps that will speak to that. But let me say this, Spoon TV should have, even if the CEO is outside of Liberia, they may have registered that entity in Liberia. So it's a corporate entity that's in existence. Hence, there should be an administrative structure as per their as per their article of incorporation. So that article of incorporation will tell you who is or who are the leaders of the Spoon TV. So if they decided to sue the Spoon TV, they're not going for Waterspoon, who is in America. They will be suing the officials in Liberia who can sue and be sued. Let's say there's a board of directors in there and they can't find one person. I'm sure those who came into action should know the structure of the Spoon leadership in Liberia. and by that, it should go after those persons. Witherspoon being here, I don't think he will file an article of incorporation in Liberia and only have his name on the article of incorporation. I don't think those at the foreign ministry or what they call, I think that's where you file the article of incorporation. I don't think those persons will sit in there and allow. It happened. I had to file an article of incorporation for someone in Liberia, and the person was here, and I told the person, no, you cannot attach your name to that article of incorporation. If you have your child, you have somebody on the ground, it is more appropriate that you put that person's name on there. Your name can be there, but you must, of course, include someone in Liberia on that, because these are some of the reasons why you do that. Wherein you have to sue or they have to sue you, there must be people who will represent you. There must be a party representing. It's called a party agent, right? You must have an agent on the ground that will be able to sue and also
the registered agent. The registered agent.
Right, registered agent, right. So that's why it's important.
Let me make quick clarification here on two things. One, when a actual damages by attachment is filed, and there is something called the judge's order that the lawyer will present to the judge, meaning ordering that the attachment be issued. The attachment, along with the writ of summons, along with the complaint, that is, if the case were filed together, will all be served on the defendant or defendant.
Right.
The court, until when they are served, the court will have will temporarily, and I mentioned the word temporarily, take hold and custody of the property. Let's assume that the building that Spoon Network is in is owned by, and I say let's assume, I do not know what is owned by Spoon. It's owned by Spoon and not leased from someone else, owned by somebody else, but leased to Spoon Network. Then the government will lock the door as you saw them doing. I mean, the court, not the government, the court will lock the door as you saw them doing temporarily until the counsel for the defendant would file what they call a returns.
Right. That was my question. So
file a return to the petition for attachment and also file a motion to lift the attachment. In that, all of the ground I just read to you, if I'm representing the client in question, I will lay out this ground and say that none of these ground exists. So therefore, Your Honor, with a bond, when you file the resistance, you must also file a bond along with your motion to lift the attachment. Because if none of these grounds are available, then the court will lift the attachment. It will conduct hearing. There will be argument for the petition for attachment. There will be argument, which is the returns for the defendant that are attached. They are now called respondent. The respondents are bond. They will file it, and when they argue and say that these things do not exist, then the court will do two things. Either the court will say, okay, all of the grounds exist and will grant the attachment, meaning that the property will remain permanently seized under the jurisdiction of the court until the case is decided, because the plaintiff has said that there is a probability that the property could be sold or something could happen. And therefore, the court will seize that. But in the meantime, the service of the rate and the seizure of the place will be legally proper, provided the building in question is owned by Mr. Witherspoon. And if the building is not owned by Mr. Witherspoon, it's a lessee, you can't lock the door, then you run it into eviction, something like that.
Thank you. Before we proceed to the next and final issue, we also want to state that once upon a time, people were, they had a big feast among all the animals, and they said, let the ugly people go draw water. And then Bamboo said, me and I want to carry a heavy bucket. Say, but Mabu, nobody call your name.
So you're not ugly.
Here is the governor of Labrador. Say the governor of Labrador wishes to clarify that it is not party to the lawsuit brought against the management of Spoon Network, which on Friday, July 14, resulted into the closure of the station's building or offices, right?
Yeah.
So, government, who brought you inside this thing here?
The way the government, the other thing is, I do not know whether Mr. Weeder listens to legal wisdom I do not know whether he is listening to Councilor Musa Dean. Musa Dean is not a bad lawyer. He's a very good lawyer. When he gave his advice, I think politics seems to be override to override most of the cases. As we said, the government Liberia is not a party. The rate shows that it is Mr. Wilman Smith versus Spoon Network and Stanton Witherspoon. So why are you talking? What is it you're talking about?
All right.
No play politics.
That leads us to our last point here, which is the authority.
The LRA.
The authority of the LRA. And let me bring you to one case. Simrex Oil and Gas, owned by Musa Hassan Bello, the storage facility at LPRC and the Star Base, were Tuesday afternoon shut down by the Liberia Revenue Authority, allegedly over tax evasion. So the LRA is the one that's collecting revenue for government. So if I'm owing the LRA, can they come and shut me down, or what should the procedure be before they close my company down? So that's what brings us to the authority of the LRA. Question: can the LRA shut down a business operating in Liberia in the absence of due process? Lawyers? And that's one reason I always want people to watch Focus on Liberia, because this is where, we discuss these things. The other people discuss opinion. And where you having senators
saying our with TZ group before. Let me begin. I think Jason. Let me begin. If you read the time they shut down Mr. Bilete, Musa Hassan Bilete, oil company and whatsoever it is, you know what it said? I don't know what is correct, but it says that for tax evasion.
Yeah.
Tax evasion is a crime. So when it is alleged that Mr. Musa Bilete did not pay his taxes, or not even did not pay his taxes, but it cheated the government in paying the taxes or devalue some of the thing he brought into the country, it's tax evasion. That's a crime. So that's a matter that the Minister of Justice must go to court and pray for a criminal rate to arrest Mr. Musa Bilete and others that operate that company. So that's a separate issue. If tax evasion is a crime, it's not like failure to pay your taxes. Failure to pay your taxes is not a crime.
No.
You'll be owing taxes. But when you decide to devalue so that you can pay small money instead of the money that you're supposed to pay, that tax evasion. But what LRA did was that they went and they said, if that what you just read is correct, LRA went ahead and closed down the office. So when a business entity that operates under the laws of Liberia as a corporation or a sole proprietorship fails to pay its taxes, LRA as an administrative organ of the government of Liberia has no authority to send people to lock the doors and nail the doors. I think this is not the first one. This is not the first one, though. I think Ellen Johnson said it time that one also happened. They were locking people doors for taxes. The LRA must go to the tax court and file a complaint. And the court must issue a rate. And there must be a hearing. That's what we say, judicial process and due process of law. And if the tax court rules that pay the $1.8 million that you owe as taxes, Mr. Bilete, until the taxes are paid, the court will order that the place is shut, not LRA. The authority for due process is not LRA, is not vested in LRA. It's vested in the courts of Liberia. Then the document he sent I looked at is that there is $12 million owned by some Cole, Mr. I think Mr. and Mrs. Cole, something like that. And LRA is involved, and I think I guess maybe the building in question, I don't know how it tied to something about it. It seems like the building in question may be owned by the Cole family. But if the building in question is owned by the Cole family, then the court could not lock it, because then what you call it, could not shut down Spoon Talk in there. and lock the place up, because then the property in question doesn't belong to the spoon. So attachment will not be will not hold, because it cannot attach a property that is not owned by spoon. But generally, all administrative agencies, and somebody might say, they have hearing officer at the LRA that conducted a hearing to say the taxes were not paid. So LRA, after the hearing officer went ahead and locked the place. If they had hearing officers, meaning people who listen to tax law at the LRA and then make a ruling, the next step is in the tax code.
Yeah.
So the petition for judicial review, even if the person did not pay the tax and did not announce appeal from the hearing officer ruling, the LRA lawyers must file a petition before the tax code for judicial review, ordering that the judgment from the hearing officer at the LRA be enforced. They can't go by themselves and start locking doors. I was in Liberia during the COVID-19. I was there January, I think, 26, and I left from there July 13, 2020. I was in Liberia when Front Page Africa, running here, was traveling. According to him, he was traveling, going through Vatan, and my friend, who is also an associate justice, was coming from New Town and going to the court. And the associate justice left his lane. The driver left the lane and went on the side of went on the lane where you call him?
Rodney.
Yeah, Rodney was driving. And as a result of that, when the justice got to the court and cited Mr. Renicier and the Front Page people to come because it was a disrespect to the Supreme Court. Oh, it just leaves the link that he should be traveling on. The law provides for, but you know what happened when the lawyer for Front Page and I think and Rennie appeared, the justice pulled from his drawer one law that says the government official can leave the link and go drive on the other side. Imagine that people can leave the side of the street that they should be driving on and come onto your side and begin to drive there because there is a traffic law that they pass in the night. I don't know where they pass that law. And so if you've been in Liberia recently, or even from the time I was there, you'll find that taxi drivers, everybody, when you think the traffic is black on your side, go on the other side and start driving. Liberia has become a complete lawless state. I never saw that when I went to Liberia when Mrs. Ellen Johnson Sirleaf was there. I did not like her. I thought her policies were wrong. But I never saw people taxi drivers leaving their side to go on the opposite lane to drive. So lawlessness has seemed to, and it becoming a problem even in the court system.
Right. I mean, that's something different. And sometimes you look at it, you ask yourself what the Ministry of Transportation is doing, because I mean, that's not a topic here, but I guess, as you said, people are not even strategizing. People are not understanding that there is a continuous problem. If you have transportation and people are not traveling freely, there's no free movement, that should be a concern for those who are at the point of the public position to even continue to think and strategize and how to find solution. But it's getting worse every day. I was in Liberia 2019. That was the worst situation too that I saw. People don't have respect, and there's no really, means. I was asking myself, is Liberian people don't have brain like other people to sit down and even strategize? No. Why would that be a traffic where someone will sit down 5 hours in traffic and can do nothing? But besides that, I think that's something else maybe we can consider later on.
I'm talking about how lawless the country has become because, for example, first, why did the government issue a press release? It did not.
Right, and let me respond to that because I think it's all political, and one of our listener here mentions, I think the government made that comment because Unity Party accused the government of closing down the station because they support Unity Party. So when this thing happened, the Unity Party issued a press statement And part of the press statement reads thus: said today, we continue to witness a troubling pattern of the Weah administration suppressing the independent press through kakistocratic means. And he said an example of such casualty is the Spoon Network, which includes Spoon FM, Fabric FM, Super FM, and their online TV, which was forcibly shut down this morning due to the government of Liberia's inability to tolerate dissenting opinions. This is from Mr. Joseph Newman Boaka in the Unity Party. So the government came out and said, hey, this thing that happened, we're not part of it.
So
I think the crux of this matter, and we all should say here, the councillor said it, is that it doesn't matter who is involved, it doesn't matter who is being sued. Due process is a cardinal and the constitutional guarantee, process that everyone should always be accorded. Relating this to the LRA and even accountability, whether there is even tax evasion, the best you can do is to ensure that there is a due process accorded. Like you said, if the LRA has a hearing officer, like at the Ministry of Labor or even the National Election Commission, there are procedural steps that people follow. And except if we are mixing all of the fights, I say that because if the LRA law is providing for them that after the hearing officer's hearing, they can proceed further with their decision, then that's something that we cannot say and say. Maybe we can say the law runs contrary from either the Constitution and the statute, but in the first place, to run to an institution and close it down, there must have been some procedure. There must be due process accorded. You might have cited the party. Party might have appeared with their legal counsels to defend themselves, and from the hearing, whatever decision comes from there, then of course they can proceed and do what they need to do.
Even can I just come in and make clarification? Even if the statute created LRA gave the LRA the power to shut down people places after a hearing officer had made a decision, a prohibition proceeding will stop the LRA in its seat, because the right to appeal or the right for judicial review is a constitutional right.
I agree, but why if there was no application, Councillor? Why if there was no application made on the part of the defendant?
So if the defendant, if the LRA had a judgment from the hearing officer, and they appear there with somebody called lawyer who did not know that he or she need to announce a appeal from the judgment,
right.
And the LRA, and there was no appeal at all. And the LRA then had before it only the judgment from the hearing officer. The LRA cannot enforce the judgment. It must go to the tax court and apply for judicial review for the sustainability or the sustenance, or for the sustaining rather of that judgment. So on all of this is to show due process of law.
I agree. So then I agree with you, but this is also the issue, and I think maybe probably someone had to make a research. The law of the statute creating the LRA and probably the provision that deals with they having a hearing, if it is faulty, as per another existing statute that explained to the enforcement proceeding as to, so then they will have to go back. Maybe someone in the country will have to look at that, either challenge what their statute is saying so they can make those necessary
corrections. So the way to proceed with that is that even if the statute gives them that power, and if you're appearing to represent your client, let's say Musa Ability is your client, you must be able to announce appeal and allow for judicial review of that judgment. Right. And if the tax court sustain the judgment and say that because the law that created LRA say that they can enforce the judgment, you must go on appeal to the Supreme Court.
I agree. I mean that there's no argument about that.
Yeah,
and then there's an appeal announced.
All I'm saying is that will suffocate the rights of the defendant from the way you call it. We do away with the right of the defendant because due process of law is not allowed. Any statute that is made that say that the administrative agency
no
has the
due
right
process.
to the judgment. It's a non-due process.
Not involved.
But you must
Thank you.
the court.
Gentlemen, we're talking about non-lawyers commenting
Right.
on these cases. I want to give an example of what we just read from the Unity Party, and without being political, do you think the Unity Party, that statement, without even understanding, I don't know if they're being advised by a lawyer that this can happen, the Unity Party came out clearly and said, this is wrong, they are suppressing, this is a dissenting opinion, and blah, 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 right? Is that interference?
Let me tell you something. I think I think the Unity Party, if it has a lawyer, must refer all of its press releases, particularly press releases that got to do with legal matter, to the lawyer to be. I know what the councilor name, Councilor Bushi Ben Keita, is a lawyer. I think he's a lead lawyer for the Unity Party. I do not believe that statement or what passed on to him to review, because quite frankly, the parties before the Civil Law Court is Waymore Smith, plaintiff, versus Spoon Network and Stanton Peabody, Stanton Witherspoon rather. So United Party could not be releasing a statement saying it's suppressing the press. Unless you have proof, you have to establish that the government is suppressing the press by closing down Spoon. Maybe by locking the doors and things, you consider suppressing the press. The question that will come about for a lawyer is that the lawyer will have to investigate, the United Party lawyer will have to investigate to see whether the building that was locked with EPP locks is owned by Stanton Witherspoon and Spoon Network. But if you look at the writ of summons, you look at the complaint, you will see Stanton Witherspoon is sued in his personal capacity, and Spoon Network is sued in its corporate capacity. Both of them can be on the same rate at the same time. Again, I may be letting the cat.
I think for that, let me say this. And indeed, it's a serious issue when it comes to non-lawyers parties in law in Liberia. Everyone has the opportunity. The Louis Arthur Graham School of Law was funded by Rudolph Graham, and everyone has the opportunity to go to law school. Sometimes you talk, people say a lot of stuff. But you go to law school, spend 3 years or more. When you out of there, there's a procedure. You sit the bar exam, and you get admitted to practice law. And from that procedure, no one is allowed to practice law in Liberia. But like you said, Mr. Jad and Councilor Jayweh, a lot of things are happening in Liberia. Everyone seems to be lawyers. People discuss everything. Even when you come to talk legal issues, people come and think and even challenge you like you know nothing, that you should be quiet. That the non-lawyers speak like they know the law. And this is becoming serious. The Liberian National Bar is quiet. The Judicial Committee of the House. In fact, this is an issue that I want to raise this. Councilor Vani Sherman is my former professor. He's being a smart man. I knew him when I was on his voice. But for all of them to sit there, they know that non-lawyers are not supposed to practice. Why are non-lawyers on the Judicial Committee in both houses?
It's a practice of law.
That's a practice of law. These people are supposed to be looking at statute, the language of the statute, make amendment or recommendation for amendment or for a repeal, or create another form of law for the entire legislature to pass.
Thank you.
That is law. So we do not think.
Yeah, go ahead. I want to announce the call because we have callers now waiting.
Okay, we do not think like my own friend and brother Darius DeLong, when he gets on the social media, he presents himself as being the one who has practiced law on a TCGU, and then he knows the law than anybody else. In reality, Darius didn't go to school. I mean, the opportunity is still there. You still have age, there's nothing stopping him to do what he needed to do to qualify himself. But to be not pretending to be practicing law, there's no reason why the Liberian National Bar should be there. They will not even call Darius DeLong to appoint. All right? And now under Darius DeLong, even the entire Judicial Committee, I'm not sure all of the members of the Judicial Committee are lawyers of both houses. That should be the concern for those who spend their hard-earned money, who went through the process of becoming lawyer, to also ask the necessary question. Some of the bar convention, these are issues that they should be discussing so that they can put a stop to these kind of issues. That will make people to go to law school. A direct donor has been called to a point where he's been challenged or even dragged to court and say, look, Mr. Man, this is the procedure laid down as to how you can practice law. Your actions suggest that you are practicing law. Now, the question would be, how will you even want to do that when the judicial committee, the first branch of government, has in fact placed these persons who are not loyal on judicial committee? All right?
Okay. Thank you.
So these are the problems I think Liberia, and it's going into other professions. Everybody want to be everything. So even come to talk, like I even see some comment that people think like, when you want to discuss the issue, people either come after you. You don't even understand the ramifications or whatever is going through. They just feel that, this is what it should be.
2 days ago, everybody was cardiologists discussing Mr. Bwaka's health.
Oh, yeah.
I heard some cardiologists say, "Oh, you get the artery from this place, you put it to the other place." But if you want to be part of the conversation, the number to call is 605-313-6004. The code is 791-403-POW. I think we have 2 callers already. Let me pick the first one, and that's Elvis Morris. Elvis, you're live.
Thank you, Mr. John. Thank you to Attorney Jensen and Counselor Jayweh. Gentlemen, thank you for your clarifications, and I will ask for further clarification on my questions. In the case of Stanton Witherspoon, I think the gentleman had made a request for a retraction and an apology before he even filed his lawsuit. I think Stanton refused to do so. And then in that same, breath, does Stanton lawyer get a second bite at the apple, so to speak? If the judge ruled against him in, absentia, or if he wasn't there to represent himself through his lawyer, can he then go back and get a second bite to say, well, I wasn't here, but I'm here now? And can the case then be relitigated in terms of a trial and whatever?
But the case is not tried yet. The case is not tried yet, Elvis.
So there hasn't been a judgment made against him? I thought we read it in front page. I forgot that it was like $3 million or $1.5 million judgment against Stanton a few months ago.
That's news to me.
Right. So,
I think I heard that, but this is what I would say to the caller. Okay, maybe let the caller rest, right?
Let him finish. Right. Go ahead, Evans. You got more callers.
And then the case with Cllr Scott, I think Councilor Jayweh was explaining it, but he kind of glanced over it a little bit. You mentioned the issue of if the presumption is great, then she could be denied bail. And that, I think, would be subjective, right, to the judge. If he looked at the evidence and he presumed, if he, decides that the evidence is just too great and the possibility of her being guilty is great, and thereby he decides to, withhold bail from her, that would be his discretion. Wouldn't it be so, Councilor Jayweh or Attorney Jensen? So maybe you guys can give us more clarification on those issues. I thank you for coming on the show tonight. Thank you for taking my call.
Thank you. Please jot that down. Let me bring in the next caller here. I'm trying my best so that he will remain on the law side, not political. Mr. Aliyu Kamara.
Aliyu. Yeah, we're still on the law side. Yeah. How are you? Yeah. First of all, let me just say to Councilor Jayweh, my people, listen, my first reason for calling here tonight is for you to give Dennis Jah the permission to give me your number both in Liberia and in America. So hopefully you give him that permission. When Councilor Jayweh speaks the law, it's difficult for a guy like me, who is a complete novice, to have an opinion because I get educated, to be frank with you. And there's one thing about the law. The law is one of those things that you cannot just go on Google and learn. The law is one of those things that you actually have to go to school for. It's not like history, sociology, and that kind of stuff that you can really comprehend at any level. So I just want to say, great education. Every time he comes on, I want to be here. And focus, I want to thank you for focus on Liberia. You bring something different. I wish we had this sort of innovation where people see stuff and a little bit diverse from the norm, from the culture of how things are done to a whole different level. Hopefully, we can get to a stage where focus on Liberia is actually represented in the media space within the country, full flesh. We look forward to that day,
Yes.
and God bless, man. I will still be here watching.
The day is coming, Aliyu. Let's keep our fingers crossed.
Aliyu, Mr. Dennis can give my number to you.
I'm waiting for that day, man. I'll be here watching.
Okay.
Dennis can give my number to you. I authorize him to do that.
Thank you, sir. Let me bring in my friend, Derek Paul. Derek?
Yes, sir. Thank you for taking my call. So, with that being said, does that mean FOL will be looking for investors in the future?
We are looking for investors now. We want to operate the biggest radio station from Cape Palmas to Cape Mount.
Okay, all right. We'll be looking in that direction. Okay, but yeah, thank you for the opportunity. So, my question is a bit wacky because it goes two ways, right? The first one is, what does the law say, about a person that is under, criminal indictment, right? Having, as it pertains to their freedom of speech, especially the election year, and they're considering if the person is in country versus diaspora, just the whole mix, you know what I mean? What does the law say around that? That's the first question. And my next question is, can the government just deem a person to be maybe a troublemaker, right? Based on the person's expression over the period of time, right? And I'll give the example, right? And just deem the person to be a troublemaker and just go ahead and shut them down. The reason is there have been a real barrage of attacks on Madame Sharif. Right. I mean, again, it's all propaganda. It's all elections. I think I heard that people had to come out and say just recently, Mr. Fagon made a statement that even the U.S. ambassador leaving, it was instrumental by her. You know what I mean? Until somebody from her camp had to come out and say this is wrong and this is evil and stuff like that. So can the government get somebody as being, a troublemaker, causing problem, and just maybe shut them down? That's my two question.
Thank you. Let me take the last call here, and that's Terry Lion Yakun. Terry, you are live.
Yeah, thank you, Mr. for taking the call. As you know, Terry Lion Yakun is not a lawyer, but I only came to address after Jayweh, one of my favorite lawyers in the country, and I'm looking forward for him to take care of my land deeds and the documentation. Although I thought the lawyers and his colleagues also too, I think they are trying to be more authentic and because they know that very sensitive issue with the government citizenry, and they're trying to provide the education necessary. I think so far they've been more authentic. I just want to try to encourage them more to really get the necessary education when it comes to the law. Because people are trying to put hands on my government and my president, and I was first and foremost motion I came here for to make people understand that my president is innocent and my government is innocent. The executive, they only trying to do the necessary thing. So thank you for this. I'm at work, and I'll just try to encourage Dr. Jayweh and other lawyers are listening, and what's not the target to Darren Dillon, they're looking into the law. We need to go back to school and defend himself of the violence of the law in the position. Thank you very much.
Thank you, Terry,
for taking the call.
Thank you. Anthony Jensen, Councillor Jayweh, your callers.
I think there are few things that I heard and I want to address them. The first caller talked about when presumption is great, what happened in that instant case. the law is clear, and presumption really, in the case of evidence, it is glaring. Like if somebody is killed, that innocence of whoever is accused is a constitutional right until proven guilty. Now, just on the face of some, like in the case of this girl, Charlotte Musu, there is doubt in the mind of many Liberians, even not a lawyer, that physical showing that will at least give a clue that someone is actually the doer of the act. In law, we say that mens rea, that physical showing that somebody actually is involved in killing someone must be demonstrated. In the case of that, you cannot bill a person. And we said from the onset that bill being a right, but even judges have right. They can look at the purpose of the law is not to keep people in jail perpetually without trial. The purpose of the law is to ensure a speedy trial and to find someone guilty when the evidence so speaks. So you're not going to sit and just say, well, the evidence is great, so we're going to deny someone a bill. That cannot just be the matter of the judge. The judge is sitting to listen to all the pieces of evidence. Or in the case of the grand jury, they look at all of the pieces of evidence. You must be able to convince the grand jury before they can come up with an indictment. And when the indictment is drawn, it's presented to court, and all the arguments follow through. So yes, if and only if the presumption is great, under those circumstances, bail can be denied. But bear in mind that the purpose of the law is not to deny a criminal defendant, a speedy trial or fair trial, but rather to lock them up. Like we heard, the very day Groska and others were jailed, there was some party. That's an assumption. I'm not in Liberia. There were some people at the city hall, they were dancing and celebrating. When we hear some of those things, it means people are not even keen as to the legal process as to what's to go on. The second thing I heard was the guy was talking about spoons, service to person. The civil procedure law established how to serve a summon on a party. Let's say, for example, spoon is not, if this guy is the only incorporator or the so-called registered agent of the spoon network in Liberia, and he is not a resident in Liberia, there are procedures established as to how to bring it under the jurisdiction of the court. I think everybody should know this man's address. Let us assume, I'm just saying, but I'm not thinking they did that craziness, that they went, they filed an article incorporated in Liberia and used this man's name alone as the registered agent while he's sitting here. So probably that will also be a mistake on the part of those who file a lawsuit, because if they don't know the registered agent of the institution and they went after spoon, like a Witherspoon, then that's a serious error. But assuming that Witherspoon is the only agent on the article of incorporation, they have his address. All they need to do is to show the court that they have mailed this brother the precept, or quote unquote the summon, and that showing is done. In that this Witherspoon fellow's address is known and he has been informed, and this maybe the mail people, the post office or DHL or whatever, there's a showing that they received the mail and then there was a precept sent to this brother, because I think his address is not in hearing. Because if he received it and he here and he's a registered agent in Liberia, he should definitely go to Liberia and represent himself or represent the institution. If he doesn't do, maybe on 2 or 3 occasions they are showing that mail was being sent to him and he did not honor that, definitely they can move the court to close on the institution. Under those circumstances, some of us will think that the action was right. But if there is no showing that you try as much as possible to accord these people due process, then of course you are in fundamental error and you are in violation of the Constitution. That's what I wanted to say. And the last thing I want to say about the fellow who talk about troublemakers being shut down, like somebody being a troublemaker, what should the government do? The government cannot just go after hearing people on public radio station and declaring them to be troublemaker. If the government has any reason that there are people who are disturbing the peace of the country or are involved in acts, tantamount to creating violence in Liberia, the court process is the best way to do. But the problem is some of these people don't even try as much as possible to get the evidence on these people to proceed in court of law. But it's not just sufficient just to get up in the morning, hear somebody on the radio, and then you try to get them, or close down, or you take actions or describe them as troublemakers. If I'm in government and even assisting like the Ministry of Justice, I'll be very keen. When people are speaking on radio stations or making public comment, we just will have to be keen. If there are comments that are of threat to the country, maybe we'll get a recording and make sure that we can provide a clear evidence against anybody who disturbing the peace. And then go to the court. Let the court call those people, let them have their lawyers, let it be battle in the courtroom, and the decision of the court, we can proceed therefore. But it's not just sufficient to start describing people as troublemakers because Jayweh are your president or maybe whoever is a political leader or what have you. The important thing is we all want Liberia to be a peaceful process. They must follow the rule of law. That's the key here.
Thank you.
Yeah, that's what I got from the caller. If there's anything we miss out, we probably can add.
Let me answer the due process. The proof is evident and presumption is great. Not just a legal jargon there. But what it's saying is that during preliminary hearing, if the government establishes that the defendant charged with the crime of murder, consistent with the new penal code of Liberia, the evidence is overwhelming. So many things will make the court to believe that those charged with murder indeed committed murder. Then the court would deny the bail. Mind you, this is not a trial proceeding. This is a proceeding for preliminary hearing. The other thing I want to add is that there are people who will say, oh, this case is a murder. Why did the magistrate issue writ? And the case also goes straight to the circuit court. No. All magistrates in Liberia, all justices of the peace in Liberia have the right to issue writ of arrest for any offense that is alleged to be committed. They do not have the right to try the case and convict the defendant in question because they lack trial jurisdiction. Only the circuit court has the right to try and convict the defendant. Now, if that's why they say, the law says that once a writ is issued, a preliminary examination can be prayed for, a motion can be made at the magistrate court for preliminary examination. If it is established that the government doesn't really, let me backtrack myself. Recently, in the scene, Gloria Mususka case, after the bill was denied by the circuit court, the lawyer for Councillor Gloria Mususka and her family, 3 family members, filed a motion for discovery. Yeah. What that means is that the defendants are saying, Gloria Mususka and her family people, along with the lawyer, are saying, give us all of the evidence you have to prove that the crime was committed. That's what the law requires. Under a discovery proceeding, the state must produce every piece of evidence it has, including the witnesses they had to testify. Right. I guess what the government, what the Minister of Justice did.
They ran to the Supreme Court, right?
To the Supreme Court, Justice in Chambers.
And the Supreme Court denied them.
Yeah. But let me tell you what, I mean, it's funny to me because you say, and again, may the soul of Shalom Musu Scott rest in peace. God knows who murdered her. But the government has not done favor to itself.
Right.
If you have, I'm sure all the press, including Mr. Jayweh, may have read the indictment. I will not go into the indictment because if I were a lawyer, there are many things were going to happen. We will not even be where we are right now with many things will happen. because I know many things that the government did not do, that the state did not do. Why was it so vexing for the government of Liberia to run to the Supreme Court? Stop them.
I know, right? And you know you had the evidence. The reason why you cannot court. Just share the evidence with us.
You indicted these people. You say the late Sharon Musu, again, may her soul rest in peace. You say she was stabbed 9 times. Where's the knife? Go bring the knife.
Yeah.
During the trial,
this is
go bring the knife out to see. The knife you say they used to kill this guy. You go bring it. You say there were no intruder because the place was locked. Show me the picture. When you went there, you took picture. And of the crime scene, they put it Liberian way. What the picture you took? Yes, you have it. You say people told you that nobody went in, nobody went out. Why are those people? You scared to show their names, their addresses?
And you went to the Supreme Court.
And you went to the Supreme Court and say, no. It's too soon.
I'll go by.
The justice in chamber said, you carry your nonsense down there. Go back there. Go back to the court below. They'll go prove your case. Because this in the discovery process, that's what happened.
Yeah, exchange.
I will add this, and I also add it, but I will add this. The indictment is, in my mind, so defective, so disconnected, so disjointed, that again, God forbid, this case will go the other way. Little Musu, shallow Musu's cat may be buried without the Liberian people knowing who really killed her. Because if you read the indictment, they talk about treason in the indictment. I never see murder case, they put treason business inside. Let me tell the Liberian, I never see treason business in murder case. They say somebody was killed, then you say treason. Who are overthrowing the government? So why are you citing the statute that talk about treason? If you read it,
we missed it. But I think we exhausted our topics for tonight.
Yeah.
So it's time to draw down the curtains. Let me get your 1 minute parting comment, and then we can
before we close. There's a guy, the same fellow, man, the fellow who called Elvis, right? He says Stanton cannot leave the country. He's indicted, meaning he's.
Let me address that. Can I address that? I'm sorry, I did not address it. Can I address it?
Yeah. So I just want to say, we're saying this fellow, the Liberian government, the article of incorporation they file in Liberia should not even get his name alone on the article of incorporation. And I'm not sure that's the case. And we do not have the article of incorporation to know the registered agent that should be sued in Liberia. Well, but if there was a procedure and let us assume that it is only him, his name on the article of incorporation, to be the incorporator and the sole agent, registered agent, those in Liberia get a way to reach to him. The law provides, I can't give the civil procedure law citation right now, but the law says that service, proof of service, that's what the law, the complaining party need to do. They don't care whether the mayor is on an indictment, that's not the issue. So if you went and just file an article of incorporation with his sole name and you get problem here, he knows that he's not in Liberia, so when the court needs him in Liberia, he should be able to answer. How you answer? Maybe he knows how to do it. He can write a code and say, well, my people, I'm so sorry, I can't be in Liberia this time. I have an indictment. I can't leave the country and blah, blah, blah. And maybe if the court decide, they can honor they can table his case onto whatever, or they can decide other way for that.
Well, let me just address that. Our friend Elvis also is insinuating that because Mr. Stanton Peabody is indicted in the United States, Spoon Network had no business being on air. They appear to be, an indictee should not be talking about anything in Liberia, like politics and whatnot. The laws in the United States that may have indicted Mr. Witherspoon is far different. In fact, Liberia has no jurisdiction in the case in the United States.
I agree.
Equally so, the case that Mr. Stanton Witherspoon and his network have in Liberia, the courts in the United States have no jurisdiction. So whether he's indicted, he's not indicted, the government of Liberia cannot stop his station from.
Yeah, they got nothing to do with that.
That's the kind of thing that happened that will cause problem for the country. And we don't want that kind of thing to cause a problem for the country. Now, let me go back to, a corporation under the laws of Liberia is a person,
Right.
legal person. It can be represented by the president and CEO. It can be represented by the general manager. It can be represented by the treasurer in the corporation. It can be represented by the secretary, or it can be represented by the corporate agent, registered agent.
Right.
So a corporation and an individual in his individual capacity cannot be sued together. They can't be on the same rate. It cannot be defendant one, defendant two. It can't.
But what, again, that's what I would say. Why, if this individual is a sole, now that would be a problem, right? Because Liberia people are not too careful. Why, if he's the sole registered agent, the sole incorporator?
Counselor, it's not the issue of registered agent. Is the corporation can have one incorporator.
Yeah.
And the Mr. Stanton Witherspoon could be on as the only incorporator.
Right.
But the incorporator is different from the registered agent. So the reason for a registered agent is for the code to serve processes, code documents that's supposed to go to the corporation.
But Councilor, that's what I'm saying. Why, if the man being the incorporator use his name as the registered agent for the corporation?
Yeah. But even with that, Councilor, if Mr. Witherspoon is the only registered agent, is the only incorporator, there exists how do you call them? Presidency. How do you call the woman in Liberia? She's CEO.
She's the CEO.
Yeah, she's the CEO. So she represents the corporation.
Okay.
But you can't sue. You cannot sue. That's why suing both of them is legally wrong, because the corporation is a person on its own. So when you sue the corporation, you don't. If Spoon Network have been sued all by itself, they don't need Stanton people to be served. You can serve Titi Kane.
Right.
With the next person to TT. You can serve any of the corporate officers that are running their day-to-day activity in Liberia. Why are you looking for Stanton people in America? But the problem they have is that they sue and name Stanton people as an individual person, and also sue name Spoon Network as an individual person, even though it's a corporation, on the same rate and on the same complete. I'm not lawyer for them.
It doesn't matter if the Spoon Network is a sole proprietorship owned by Stanton alone.
No, well, if it is a sole proprietorship, then you don't. Then the idea.
Then you don't need two of them.
You don't need If it's a sole proprietorship, you will be suing Stanton Peabody, because every why the corporation is established is to have what they call limitation liability.
Limited liability.
But limitation liability. In order to go further, that is, if there is a judgment against the corporation, unless you can pierce the corporation view, unless you can say that the corporation and Stanton Witherspoon were acting as one and the same person.
Which likely happened, but we got to close.
Yeah.
We're out of time now. So let's close with your party comments, using at most 59 seconds each.
Well, for me, I want to say thank you for inviting me, and for Councilor Jayweh, thanks for sharing the platform with me. It's a pleasure to be here always, to speak on issues that could better Liberia's democracy. So it's a pleasure. Relative to all the cases, we hope that lawyers in Liberia will be key and take some necessary steps, if necessary, to even review the statutes or some of these regulations. They should be champions of these laws, so that to better Liberia. Relative to due process is a constitutional right, and we think the Liberian government and all the parties, we have to respect that, no matter who is involved, what name it is. So with that being said, once again, we hope that Liberia can get better. Those who practice in law, you don't have law degree, it's easy. Just go to the law school. I think they will register. In fact, it's of good advantage when you're in government. Liberia professor now think they're getting to be afraid of people. When you senator or representative, they can give you some little free grades and other stuff and what have you, right? They can give you some leverage. That's what happened.
Graduate you by teaching your grades.
Yeah, teaching whatever, and then get a view. If you go through that, you go sit the bar exam, you pass it. I mean, start worrying again, going to court. I mean, you can be proud of that, rather than condemning those who sacrifice their time to go through the process and thinking that you outside, you know the law better than them. The senators and representatives too, we think they need to look at the judicial committee of their respective houses, and then make some decisions as to what it means as to practicing law, and maybe do some adjustment in those directions.
We're not hearing.
Thank you very much, Attorney Jensen.
Yeah.
Councillor Jayweh.
As always, I will advise the Liberian people to speak to a lawyer. I mean, we have said our office is open to in a limited manner, discuss issues that may affect you. Stop listening to the politician who work for this lawyer and the lawyer this and the lawyer that. And we should encourage the Bar Association to put a stop to all the quacks, people who one day they wake up their lawyer by working in somebody's law office. Even though they were just office boys in those offices, they now have become lawyers to make authoritative statements. And let the bar call them to book. If the bar will stop filing lawsuits against people who practicing around, you don't think being on the judicial committee in the Senate is a practice of law.
Right.
You're not a lawyer and you decide to write statute, you decide to advise on that, it's a practice of law. If you're not a lawyer, you go on radio station and talk something about a law that had nothing to do with you and you don't know the content, neither do you understand the context, it's a practice of law. When people are starting to be held responsible by the court, fined, maybe thrown in prison, Minister of Justice get involved and indict people who basically running around calling themselves lawyers, then the thing will stop. The other thing is that I know Councilor Musa Dean is a very good lawyer. I will hope that the government, if it's not listening to Musa Dean, they go ahead and listen to Councilor Musa Dean. The thing we heard after the lawsuit was filed and the Spoon Network were closed, and the Maritime Commissioner and other people were at the City Hall drinking wine and having party on that particular day. It just showed that this is so elementary.
I know, right?
You're exposing the government. Why are you doing that? Why are you rejoicing? With an attachment, you're rejoicing. It means that you are in it. So we need to be very careful, because what we have from the war days to now, we don't need it anymore in Liberia. We want people who are suffering, cannot find food to eat, should be able to at least get out of their houses to go to the market and do what they wish to do, to have something for them and their children to eat, instead of trying to make conflict in the country for the place to look very bad. It doesn't impress anybody if you know that you minister, you watch whatever it is. Start making stupidity in the country, because at the end of the day, it become a problem, because we all that have family, mind you can have your wife and children here. I'm sure your cousin in Liberia and walk on that, your cousin would die.
Right.
Stupidity all about. And I will hope that we will be willing to come here at all times to clarify these things, because we think it's very helpful to our people. And to stop confusing people. When you get confused, pick up the phone. If I will ask Mr. Ja, anyone ask for my number, will not charge you money, give my number to them. I can talk to you briefly and explain something to you. I will not talk to you like I'm representing you. In other words, I'm not going deeper into your case unless I have a retention letter.
You can listen to them and make some recommendation, right?
Some recommendation, yeah. So that you can't get confused. And you can't get yourself into conflict. There's no troublemaker. Every Liberian has a right to speak. When you speak, you are responsible for your own nonsense. Take the people to court. Don't go start shutting the place down. You start to share wine and dancing all night. What is that?
I know, right?
Thank you, Councillor Jayweh. Thank you, Attorney Jensen. I want to thank our viewers, all those that have been with us tonight, even those who will watch later. Always focus on Liberia is the place to be. We run this throughout the week, right? On Tuesday at 1, we have the Hour of Politics. Tuesday, 7, we have Abby Tyler's Healthy Living. Wednesday is Roundtable Africa at 1. Now we've moved the Liberia History Channel to Wednesday 7 p.m. Thursday 7 is Tough Talking Thursday. Friday is the Literary Hour. Friday night is Debate Night. Saturday 3 p.m. is FOL Marketplace. Sunday 1 p.m. is the New Day, and On Point is 4 p.m. That's On Point, and 6 we have the FOL Justice Forum or Hello Pastor. So follow us on all major social media platforms. Gentlemen, again, thank you.
Thank you guys. I had to run.
Yeah, it's a pleasure, man.
Until then, we're going to close with our song that says, "We are all Liberians." Have a good night.
We are Liberians. Liberia is our home. Liberian people. Liberia.